Hello, I'm just trying to sort out the camera because I can't see any of you guys, but I know some of you are there. So just bear with me. Okay. Hello. I am just going to turn my computer off so that you've not got me in duplicate. We're just a tiny bit early. I'll just give it another couple of minutes. So if you can just bear with me and then we'll get started. Is everybody else on mute? Okay. All very eager and here ready, and because we said 6:30, I just don't want to start ahead and people then complain I started too soon. So we'll just give it another minute and then we'll get started. I'm hoping that we'll get through this in half an hour, 45 minutes. It does all depend how many questions that you have, and we will do some questions and answers at the end. Hello, everybody. First off, I'd like to just start by introducing myself. I'm Pauline Carrera-Silva. I've been with H&H now for about 2.5 years. I've come across a lot of you, so it's nice to get to speak to you about this. Some, of course, I've not met. I was previously working in Warwickshire, and I'm probably racked up about 30 years now in lettings. I've the regional executive for Lancashire and Cumbria for Arla, and as I said, I've been here with H&H for 2.5 years. So today is about the Renters' Rights Act, and it's coming into force as of the 1st of May. Which is the main part. The government has already introduced on the 27th of December last year the expanded local authority powers. And what I'm going to try and do today is give you some accurate information as I can. Some guidance still hasn't been confirmed. For instance, a couple of weeks ago we were given the written statements. The written statements will be alongside the tenancy agreements. However, the government have yet to publish the final version, which we're expecting about March, end of March. We've also had an update on the EPC requirements that came on the 23rd of January, which we'll cover at the end. The webinar is intended to give you an overview of the changes. It's not an in-depth discussion on the Renters' Rights Act. We will produce some leaflets and further information, which you'll be able to download and read. This is being recorded, so you'll be able to have that to play, to rewind. And as I say, welcome your questions as we go through to the end. And you can get in contact us either through the normal channels, through our marketing email, or directly to me, and we will put the contact details up. So the topics we're going to cover today is there on the list for you. So quite a few items there: the shorter hold tenancies, the new tenancy structure, the grounds for termination of tenancies, new rules on rent increases, restrictions on rent bidding, greater rights for tenants and pets, anti-discrimination, new standards for private rented homes, new landlord registration and address scheme, expanded local authority powers for enforcement. And the one that's missing on there, of course, is the EPC. I'd written this and then they produced the EPC details. So as you can tell, it's ever changing at the moment. So let's start with the AST. So from the 1st of May, all tenancy agreements will become periodic. That's month to month. Tenants will be entitled to expect a guaranteed tenancy of 12 months, although they have the right to serve notice after 28 days by giving 2 months' notice. The notice must be in line with the rent due date. For example, if a tenant gave notice on the 17th of July and their rent due date was the 1st of the month, then notice would start from the 1st of August and would expire on the 30th of September. This will be a change for the tenants. They're not used to giving 2 months' notice. We intend to do a webinar for our tenants, explain the changes to them, and we're looking to do that in a couple of weeks' time, around the 18th of February. The changes do not affect licences, contractual tenancy agreements, company tenancies, or where it's a commercial tenancy. The new tenancy structure, as mentioned, it will be a written statement of terms. They must be included in any new tenancy agreement and will replace the current short hold tenancy. All new tenants must be given a copy of the written statement at the start of the tenancy. For existing tenancies, we have been told that we will be given by the government a information sheet to give to the tenants, and that must be given to every named tenant by the 31st of May. We obviously will be doing all of that for our managed landlords. but let-only landlords will obviously need to do that themselves. Moving on to what's included in a written statement. I'm not going to go through this item by item. As I say, we will have these notes available for you, but I'll just briefly do an overview of them. So each landlord must be named on the agreement, along with an address in England or Wales. It isn't a problem for landlords using us, of course, because we are in England. We're not quite sure how this is going to affect overseas landlords or even Scottish landlords, because it is very specific about being England or Wales. And we have asked some questions on that. All tenants need to be on the tenancy agreement named. That isn't a change from where we are now. The property and the tenancy dates, full address of the property and the start date. It's as simple as that. Financial terms, what the rent is, what date the rent is due, details on how rent increases will be applied, which will be via the Section 13 notice. We'll come on to that in a little while. Which of the utilities are included in the rental, if any, and if the landlord is recharging, how much and when they need to pay that, how much the deposit is, and how the deposit will be held and paid. Then the next one is notices and security provisions, how and when the tenant can give notice, how much notice is required, how the landlord can give notice and how much notice is required. This will include a statement about the landlord requiring to get a possession order before they regain entry to the property. This is no different to the current tenancy agreement. It's already in there, so this isn't that much of a change. Statutory duties and safety obligations. The statement must cover the landlord's duties, including the fitness for human habitation obligations, repairs for duties on the structure, interior and exterior, electrical safety certificates and gas safety certificates. Additional information, this will cover such items as pets, requests for pets, disability adaptations and support from accommodation suitable for social housing. It's not really relevant on domestic rental properties. Please note this is a draft. As mentioned, we are told to expect the final version at the end of March, and this will then be available on the government website. Right, ending a tenancy. As you all know, Section 21 notice will be abolished and will be replaced by Section 8 notice. These will require specific grounds for ending the tenancy. It's worthwhile repeating here that the landlord will not be able to serve notice on tenants because they wish to sell or move back for the property for the first 12 months after they've, let me rephrase that. If a landlord serves a Section 8 notice, for whatever reason, they'll be prevented from re-letting the property within the first 12 months before. So if the property fails to sell, you won't be able to re-list it for let. You'll have to leave it empty. Any valid Section 121 notice served, but not moved out by the 1st of May, the notice will be valid if you are waiting for possession proceedings. Any such claims must be with the court, requesting a court date. It's for 3 months, so it comes in on the 1st of May. So that means it must be with the courts by the 31st of July. And that means court papers with the courts. New rules on rent increases. Rent increases can only be increased once a year, which is what we do at the moment. Via Section 13 notice, again, that's what we do at the moment. And the difference is going to be it's 2 months notice instead of 1, which is the current. And it mustn't be more than market value. We've had some questions on what is market value. Market value is the amount that we would put the property back out to re-let today. Restrictions on rent bidding. This is quite simple. It's the maximum the landlord can accept, regardless of what a prospective tenant offers. The landlord may accept less than the advertised rent, but he may not accept more. So if a tenant came to you and offered more because they wanted to have a pet, you would not be allowed to accept it. The advertised rent is the maximum you can accept. Greater tenants to keep pets. Landlords cannot unreasonably refuse a request for a tenant to keep a pet. The landlords must respond to pet requests within 28 days in writing. If a superior landlord, such as a freeholder, does not permit pets in the building and will not give permission when asked, a landlord can just refuse. This is a reasonable basis not to accept a pet. I personally would also expect on a working farm, this would fall into that category. We won't know that bit until it's challenged. But if, you know, for instance, on a working farm, you wouldn't expect it be reasonable to have a domestic cat or dog. These are things that will get tested over time. So, on to the next one. Anti-discrimination measures. So you can still choose your tenants based on the referencing, affordability checks, whether the tenant is suitable for the property. By that I mean if it's a one-bedroom flat and you've got a family of 4 applying for the property itself is obviously not suitable. It wouldn't be large enough, and therefore you could refuse on that basis. You won't be able to refuse people based on whether they have benefit, children, pets. That's obviously in addition to the normal discrimination of race, sex, sexual preference. New standards for the private rented homes. The government ran out a decent home standards up until about the 10th of September. I think it's going to be a little while before they publish the results of the consultation, and the decent home standards isn't expected in until 2035. The part that we are going to be affected by is Arab's Law, and that will start from October this year. We're expecting more details on the timescales, but current timescales for the social housing sector is 2 weeks to investigate issues and then 7 days to begin repairs. So we can expect this as a guide, but the government have said that they do understand that on the private rented sector, we will need a little bit more time because us as agents will need to consult with you landlords about any repairs required and where we need to go next with that. New landlords registration and redress requirements. All landlords will be expected to register on the new private rented sector database. The private rented sector landlords ombudsman is going to be approved around 26-27, with all landlords expected to sign up by 2028. All landlords will be expected to be registered, even if they use an agent. They have said it's going to be a not-for-profit organisation. This hasn't been confirmed. They've also said the fees applicable will be small, but we haven't had any confirmation on that. They haven't even appointed who is going to run it yet. So until they do that, we're not going to have any more information. On to the next one. Expanded local authority powers for enforcement. This started on the 27th of December. Local councils have a range of new investigatory powers which allow them to enforce legislation and allows local authorities to gather evidence for breach or an offence has taken place. They have to be satisfied beyond reasonable doubt that there is an issue before issuing a fine. The fines are between 7,000 and 40,000, and things that you would expect to be on there are things like not renewing gas safety certificates, electrical safety certificates, not being compliant on smoke detectors, CO2 detectors, those type of issues. EPCs are the ones that I haven't got on here. The proposed new deadline for this is now, it was 2028. That's now been moved. It is now 2030. And the good news is they were going to increase the cap from 3,500 to 15,000. They've agreed to reduce it to 10,000. They have also agreed that to be able to apply for an exemption, it is 10% or the 10,000. So, for instance, if you had got a house of £100,000 value, then £10,000 would be obviously what you need to spend before you can apply for the exemption. If you had a house of 60, that would be 6,000. They are going to change the metrics for EPCs, and that's due out in October. And it's now going to be based on, and I'm sorry, I do need to read this, 4 clear metrics: energy costs, fabric performance, heating systems, and smart readiness. The EPCs brought out after that time will be then valid until, if it's done before 2029, it will then be deemed valid until the certificate expires. They have issued some grants on boilers. All of this, though, is aimed at either private ownership or social housing. There isn't any landlord schemes at the moment. They think they put 1.7 billion into owner-occupiers, and if they spend all that fund, there won't be anything left for landlords. However, it's not all spent, then they have said they will consider putting it to landlords. So, on to some questions. I will just unmute you. Fine. Okay, so I did get asked a couple of questions before we started this from people. If you do have a question, just pop it in the box and we will ask. Try and answer it for you. Okay, we've had a couple of people send in some questions. The written statement, yes, H&H will do it on behalf of managed landlords, let-only landlords. The statement will be available online. You will be able to download it.
In terms of having an address in England for serving notices, what if a landlord resides in Scotland and does not use an agent to manage their properties?
This is a question that has been, I mentioned about me being part of Property Mark, and this is a question that Property Mark have actually raised with the government, because it's you would have thought that was such a blatant error to not have included in Scotland in it. At the moment, we don't have an answer. We are waiting for them to come back to us on that question, because there is also the question of a landlord that's overseas that manages their own property. There aren't many of you that do, but there are some. We're waiting for the answer. I would have thought they will amend that.
We've got another one. As far as I understand it, EPC renewal mid-tenancy, which is missing a tenant notification of the new EPC, comes with a local council fine. I think it's £7,000. How will H&H keep evidence of notification within 30 days?
Sorry, I missed the. So I'm just going to have a read of this question. Okay, so at the moment, you only need to have a valid EPC if you are advertising the property or re-letting the property. There is no requirement to have it mid-term. you don't need it if you're not advertising the property. They have been talking about changing it, but they haven't changed it yet.
What is the latest date we can serve a no-fault Section 21 eviction under the current arrangements?
At the moment, in theory, you can sign a Section 21 notice all the way up until the 1st of May. I would recommend that if you're thinking about doing it, that you have it expiring on the 30th of April as the very last day, which means you probably need to be thinking about serving that notice this month. So it expires in line with it starting on the 1st of May. That then means if the tenant doesn't vacate, you've still got May, June, July to get your papers into the court.
We have another. I'm hoping that H&H will enable the landlord registration. Will you oversee that in some way or remind landlords?
Yeah, once we know how it's going to operate, and we have the example of Scotland, which the landlords have to register for themselves. H&H also have to be registered. Landlords themselves have to register though. When they're bringing this wholesale scheme in, I think there will be an opportunity for us to register on our managed landlords, but I don't know because we don't have the details. The Ombudsman, I think, again, they will let us act or register for you, but they haven't given us details.
For Grade 1 listed properties, where there are restrictions on upgrading properties due to statutory bodies not issuing the necessary consents due to their historic significance, how do we reach the new EPC requirements?
If you're not able to reach the requirements, I've only done this a couple of times where we've either had a property that was in the national park and there's restrictions on what you can do, or the building itself has had a restriction. You just need to show evidence of the listing. You submit it to the EPC body and they will give you the exemption. My brain's gone blank and I can't think of the name of the website, but there is a specific website where you go to the EPC exemptions, you put all the details on and you apply for the exemption online.
Can a landlord still add requirements to the tenancy agreement? For example, if tenant has a pet, landlord requiring the pet to be kept free of fleas / use of regular flea treatment. Presumably, if they do not do this and the property becomes infested in fleas, there is no recourse to serve notice on the tenant anymore.
That's a difficult one because as far as the landlords, as far as the court's are concerned, a pet having fleas and not being treated would be judged as a minor breach, not a major breach. And it would be at the discretion of a judge whether they would give you possession of the property. There would be no immediate recourse that you could use. And I'm trying to think of the new, because we have new terms of Section 8 coming out. We've got current ones now, and then we have the new ones that we've already got, but they will be enforced from the 1st of May. And I don't think there's anything in there that you could use on that instance.
Is there a provision in the standard H&H managed contract to pass on any costs, for example, landlord registration, to the tenants without issuing a new tenancy agreement?
As far as I'm aware, we still have, there will still be enforced the tenant fee ban, so you will not be able to recharge anything to the tenants. So the responsibility and the costs will be on the landlord. The thing that the landlord will have when the legislation changes, which is something that we've not really had before is this market value. So market value is what we would advertise the property at today. So if your property, you haven't increased your rent for a few years, and the rent on that property when you initially let it was 600, and in today's market it would be 725, you could reasonably ask for that rent to be increased to 725. Okay, that's all of your questions. Thank you ever so much for listening and tuning in. We will get some information to you. Oh, sorry, somebody else has asked a question, so I'll just cover that one.
Says, as a side note, Dan Needle of Tax Policy Associates says that renters will need to complete stamp duty tax returns within 3 years in the high value rentals, mostly South East England, a quirk of the RM.
Let me just have a quick look. Yes, we do expect them. There are some changes coming to, I think it's section 24 that notice. I would say to everybody, obviously they're making tax digital, so you know you all should be digital now. Submitting your returns. There will be some changes. There will be some other things. Obviously, Paul is quite up on the tax. I'm not going to pretend I am a tax specialist. It's well beyond my remit. I'm all right with rental values. When you get to the inland revenue, I'm sorry, I'm out.
Just one last question. Are you allowed as a landlord to ask if people have pets?
Yes, you're still allowed to ask if they have pets. You're just not allowed to discriminate against them because they have got a pet. So if you had somebody applying for a property, you're obviously going to want all the information to know if they're suitable for your property. I mean, I gave the example of a 1-bedroom flat. That would be a classic example where you would definitely need to know if the tenant had a pet, because if you had a restriction, you would not be allowed to accept them. But I would say that's also true of a home. You're just gathering information on your prospective tenant. It's not unreasonable to ask those questions about their employment, references, children, pets, as long as you're not using any of those elements to discriminate against them. That's great. Thank you ever so much. As I say, we will produce some leaflets and get some details out to you so that you can have them. As we get more updates, we will let you know. We will be producing one for the tenants, just so that they're aware of how the legislation affects them. Thank you.